The next case to come before the court this morning is in re AH. The appellant has waived oral argument. The appellee will have 15 minutes to present oral argument. We are recording these presentations today, and that they will be posted on the court's YouTube channel. Please don't use the names of any victims or minors. I know you probably wouldn't, but just we make that admonishment because of the fact that it will be posted on the internet.
Well, Your Honor, I'm also not going to name any of the parties in this particular case. Mother will be known as mother, father will be known as father.
Thank you. You may proceed. We've read the briefs and we're ready when you are.
All right, thank you very much. I don't know if this needs to be adjusted, but I'll just go ahead and do that. All right, may it please the court, my name is Lee Prue. I am here on behalf of the Lorain County Department of Job and Family Services, and I would request that this court affirm the Lorain County Domestic Relations Court decision granting permanent custody of the 3 children, AH, and AH, to the Lorain County Department of Children's Services. This case was brought before this particular court, the 9th District Court of Appeals, pursuant to a reported error that the juvenile court made its decision against the manifest weight of the evidence that was presented before the court during the permanent custody hearing. Now, in order for the juvenile court to have, in fact, granted permanent custody, the juvenile court needed to find, by clear and convincing evidence, the appropriate elements of Revised Code Section Statute 2151.414B. It did so in an extremely long, in my experience and practice, I think this is a very thorough ruling that the juvenile court issued when it issued its ruling. And therefore, the record in the case supports all the court's findings, and we ask this court to affirm. Now, as with all permanent custody cases that come before this court, it's a very sad case. Just to go over some of the evidence that this juvenile court found when testimony concluded, first of all, the mother in this case, unfortunately, has lost 3 children previously to permanent custody. The brief indicates exactly what dates and times those children were lost, and so I would just refer you back to the brief instead of necessarily expounding on it here. When this case was brought in June of 2021, it was necessary then for mother to come forward with a case plan that the department had issued her, and she had been issued several case plans for the children that she had previously lost, so she understood what a case plan was. She understood the responsibilities of making sure she adhered to the case plan. And it's always understood when a department issues a case plan, the goal is reunification with the children. So mother certainly had an opportunity here if she had in fact actually adhered to the case plan and completed all of its requirements that she could reunify with her children. But in this particular case, she did not do so. Some of the evidence that was provided at the hearing indicated that there were a number of things that mother needed to work on, and I will kind of go through these in an order that I think makes sense. First of all, with regard to basic needs, it was necessary for her to provide housing, and what the juvenile court found in that case is that she didn't have a job. She had not been gainfully employed for a substantial period of time. I'm not sure she was looking for work at that time. Unfortunately, I don't recall. I do know that she had moved to a house that she was not the lessee on. It was in fact her mother who was named as the person signing the lease, and she was listed as a tenant. So her tenancy in that house wasn't even actually as a tenant, it was more of a subtenant. Since she didn't actually have any legal right to even bring any kind of an action, there's all sorts of questionable rights as to whether or not that housing would have been sufficient for her to be able to stay at. In addition, the caseworker who testified on behalf of the department said that there was evidence that possibly father had been there. And I'll explain as we go on further why that's important and why it's problematic for father to have been there. In any case, there's also concern over whether or not her Social Security income would have been able to continue to pay rent. There had also been indications in testimony in this case that the mother, this is confusing because it's the mother's mother, but her mother had assisted her to some degree in trying to go against allegations that the father had engaged in domestic violence against mother, which is obviously problematic. If you have 2 people, one of whom is most assuredly a victim of domestic violence, and both of them are trying to tell the court that it's not appropriate for the court to press charges, it's not appropriate for the court to go forward with the case, please dismiss the charges if you don't actually want to bring them anymore. then there are all sorts of questions about whether that particular mother, this mother, can be trusted in a situation where children would be present, where if they were returned, that the children would be present. There's a question about whether they would be protected. There's a question about whether or not that mother even could maintain that housing, because again, she's a tenant, this isn't an owned property. So there are questions about basic needs that the trial, or the juvenile court rather, found were not met in terms of what were required under the case plan. There were also concerns about parenting. The main concern about parenting, although the court did disclose that during the supervised visits, mother was affectionate with the children, she did spend the entire time with them, she did prepare beforehand when she would go to the visits. That doesn't necessarily translate over to her ability to, in fact, take care of the children on a long-term basis on her own without anybody helping her, except maybe for her mom, and the possibility that the children's father might be involved. We have also seen testimony in this case that while the father was in jail, he would instruct the mother to berate at least one of her children over the phone. The mother would dutifully do that. So there are also concerns over whether she would be influenced by the father if those children were in her house and there was no court having any kind of supervision or even just checking to make sure that the children were safe. So there are obviously concerns about parenting. The juvenile court rightly found that the concerns about parenting had not been adequately addressed. There were concerns about mother's mental health as well. I know that she ended up doing the class that she was supposed to do. At the same time, the testimony that our worker provided was that there were still concerns about not necessarily her mental health so much as her intellectual abilities concerning the ability to keep up with the conversation that was taking place in front of her, and the fact that the worker had seen other family members intervene to tell her this is what we're talking about, in a situation where it probably would have been evident if anybody had been listening what was actually being said, so there may be some concern over delays of her understanding. And that's obviously going to be a concern over parenting as well. The domestic violence issue is the most detrimental issue with regard to this case. It makes it, in fact, one of the saddest cases I'm sure that our department has seen. There have been a number of extremely sad cases. This is obviously really, really sad. The issue, or the instance that started off this case in the first place took place in March of 2021 when the father ended up hitting mother, causing her to obtain broken ribs, having a busted lip, and getting blood all over herself. And this all took place in front of the children, so no one can imagine how difficult that must have been for them to watch their mother being beaten by their father. Now, the next incident that took place with regard to mother and father took place in May of 2022 when father grabbed mother and forcibly enough that he broke her arm, and he also punched her. Now, he was in jail during this time, and this case had been initiated in June of 2021, so it was already sort of whirling its way through the system. She was already on the case plan. She shouldn't have been seeing father in the first place, and unfortunately, she sustained some serious injuries. However, even while he was in jail for this incident that took place, there were over 80 calls between mother and father, where mother professed her love to father, where she talked about a celebratory dinner that would be planned upon his returning back home from jail. And she also wrote letters to the court in this case. Well, I'm not sure whether, I don't know whether it was her and her mother. Yes, her mother also wrote letters to the court asking that the case be dismissed, writing to the judge asking that the case be dismissed, and denying, lying basically to the court, and denying that any domestic relations or violence took place. I'm not in a position here to try to berate mother. That's really not the point here. The problem that we have is that there's the safety of the children to be aware of. And even while this particular case was taking place, another incident took place on June of 2022 on Father's Day, where father hit mother hard enough that she blacked out and she ended up going in an ambulance to the hospital, and other relatives were also there, and they had also inflicted injuries upon her. So that incident took place. The hearing for permanent custody ended up taking place in August of 2022, and in September of 2022, while this hearing is taking place, she's again on the phone with father in the jail, and the phone calls indicate that she is again expressing love for him, and again expressing the type of food that was going to be provided to him for a celebratory return from jail. All of this taking place even as this permanent custody case taking place, and the worker is testifying to all these things. And here's mother engaged in this behavior, seemingly defying exactly what the worker is testifying to, giving her even more opportunities to testify to the fact that mother, unfortunately, is just making terrible decisions with regard to the safety of her children and the way that she's interacting with father. So we have all of this evidence that has been provided to the court. And we also have a brief that's been provided by mother stating that the reason that the manifest weight of the evidence was not relied upon here is because mother had done some things in her case plan that presumably the court did not take into consideration. Mother had taken the course that she needed to take for mental illness. She had obtained housing. The fact that mother claims that she obtained housing and that was sufficient. The court clearly heard all of the evidence that was provided with regard to her housing. The court clearly heard all of her evidence with regard to her mental health. The court heard all of the evidence with regard to her affection for her children during the visitation that she would have when she would have supervised visits. The court listened to all of this. The court also heard all the evidence that was provided by the Department of Children's Services. It evaluated the credibility of the witnesses. It made its decision. It came up with a very thorough list of facts that it determined, and it determined, based on all of the evidence that was provided, that the children, let me go ahead and take a look at the actual statutory language here. The children, they could not be placed with either parent within a reasonable period of time, and they shouldn't have been placed with a reasonable period of time, pursuant to section 2151.414B1A of the Ohio Revised Code. And they specifically stated the reasons. First of all, they indicated that mother and father have, and this is pursuant to 2151.414E1, following placement outside of the children's home, and notwithstanding reasonable efforts that were made by the agency to assist mother and father, both mother and father continuously and repeatedly failed to substantially remedy the conditions causing the children to be placed outside the home. And we have ample evidence of those determinations that were made by the court. We know that the court found that her basic needs were not being met. We know that the court found that her mental health issues were not resolved. We know that the court found that her parenting concerns were not resolved. And most of all, we know that mother continued to place herself in danger and could potentially have placed her children in danger because she continually had interaction with the father of the children in a situation where he already demonstrated time and time again his propensity for violence toward mother, potentially his propensity for violence toward his children, certainly his animus toward one of his children, and berating her in front of mother and encouraging her to berate the child as well. Now, in addition, the court found that mother had lost her parental rights involuntarily and had rights involuntarily terminated with respect to siblings that were in the house. It's my opinion, Your Honors, that that actually would have been sufficient for the department to make its case. The permanent custody should be granted, but the department didn't do that. It also allowed this worker to come in and testify to all these other circumstances so that there's no reason there was no reason for the juvenile court and there's no reason for this court to question the juvenile court's determination that this particular element, 2151.414B1A, has absolutely been met in this particular case. And the court further found, as is required to do so, that it is in the best interest of the children to permanently terminate parental rights and to grant the department permanent custody of the children. In doing this, the court found that the children were now in a foster situation, that they were thriving in the situation that they were in. They found that there were no other appropriate relatives for the children to go to. Unfortunately, we see a situation where the mother's mother was not appropriate for many reasons. We also see a situation where other relatives were considered, but they decided they didn't want custody. There was no other option for the department other than to file for permanent custody in this particular case. The court made that determination based on all of the evidence. The evidence was most certainly credible, it was competent and credible, and it was clear and convincing. And based on that, this court should affirm the juvenile court's ruling of permanent custody to Lorain County Department of Children's Services. Thank you very much.
Thank you, counsel. Court will take the matter under advisement, and we will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website.
All right, thank you.